Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, they're holding up half the sky. Raise your hand if you're ready and willing, if you know it's time. Time for a girl on time. Time for a girl on time. Time for a
Hi! I figured rather than make you wait till I did my makeup, I'll do my makeup while we're watching the show. I hope everybody's doing well today. Happy Saturday. My hair is still wet from my shower, but it'll do. It'll do. Also, the fresh cookies are out of the oven, so let me know if you like one. They're delicious. If I and everybody who's ever eaten one does say so, they do. Don't worry, they do. Anyways, also I know that we've got birthdays today. I don't see birthday girl yet, but no, you had it right the first time, Naybell. But yes, birthdays. Oh, Vicky, lucky for you, I made 6 dozen. No, six dozen. I made 6 dozen cookies. Well, only the first batch is cooked. Anyways, speaking of cooked, we are going to go and watch a case, or a docket, mind you, from, hold on, I labeled it, Watch Tonight. Beautiful. I found that. That's what I found. Oh my God, will I be able to look around? It's Bronlick. Seriously though, first things first. Why can't I see over there? I have to use this one. 6 dozen. It's 72 cookies, anyways. So the whole point being that I love cookies, obviously. No, but seriously, the whole point being tonight, we're digging into the archives. Judge Bronlick, I love him so much. He's one of my favorites. And he is going to probably yell at somebody tonight. He does that a lot. It's pretty amazing. Anyways, I would love, in the meantime, to hear what you had for dinner. If you didn't like what you had for dinner, hi Rose, tell me what you wish you had for dinner. I was actually I know, Bill, I use it every day. It's literally like my little hand mirror here. Anyways, but I would love to hear what you had for dinner. And what else was I saying? Oh, Rose, I was debating showing the CPS termination case tonight. But as I was thinking about it, I was like, I don't really want to be sad. And it was sort of sad. It was really sad, in fact. So I decided to go with something else so that hopefully we have a good night. Okay. Makeup's done. Woo! Look at that. We did it together. I guess we could do our hair down or up, whatever works. Anyways, I think that's what they call effortless beauty. In my dreams. That was in my dreams. Oh my gosh! Oh my God, we're back again. Gifting from Legal Fiction. Oh, I even made it rhyme. Legal Fiction, thank you so much. And members, guess what? Tomorrow, members only is in the evening time. That's right. Keep an eye out for it. We will be together joining for our members only. I'm still on Just Water July, but Paisley style, which means no added sugar July, which doesn't have as nice a ring to it. So you'll forgive me for not, oh my God, I'm getting sweaty. It'll be like 5 or 6 East, Vicky. 5 or 6 West, East Coast time. Hi, Erica. Anyways, so I'm gonna have, oh, you can't see it because the package is green. It's raspberry lemonade, ladies and gentlemen. That's right, Paisley has maintained on her no added sugar drinking wise. No grandbaby. Well, you know, babies come when they're ready. Sort of like men. You can force it, but they'll just bother you later. So I wouldn't recommend it. I'm kidding. I love you guys so much. Seriously, if you're just getting here, please go ahead, hit that. Oh, no! No, I trusted you. I trusted you, water bottle. Your electrolyte goodness. Oh my God. I squirted all over my boobs. Okay. Let's continue. I wish you guys could have heard that concern. Shut up, ma'am. You had so much time to speak. And then now it's my turn. Also, I wish you guys could have heard that. That concerningly popped. Actually, let me see if I can replicate that again. I'm not. Hold on. Oh my gosh. It's like champagne. Ooh, it's fizzy. Is this one effervescent? Ay, ay, ay. Okay, maybe I should read.
For the record, this matter is before the court as a result of the defendant's objection to entry of a proposed judgment of divorce prepared and submitted by the plaintiff. This hearing is being conducted via Zoom. Present is Attorney Maria Zagorski, representing the plaintiff, Mark Mansick. Mr. Mansick is present. In addition, Attorney Eric Chappell is present, representing the defendant, Rebecca DeVoot, and Ms. DeVoot is present. Good afternoon, everyone.
Good
Ms.
afternoon.
Kuhn, I'm sorry, Ms. Kuhn is also present. Ms. Kuhn is co-counsel with Mr. Chappell, is that correct?
Yes, Your Honor.
Is that correct? Ms. Kuhn, you're co-counsel
Yes,
with
Your
Mr.
Honor.
Okay, yeah, I
I
thought so. Thank you. The view of the pleadings, the court was not able to grasp what the issue and dispute was. And you've conferred with the front of the court this afternoon and have not reached an agreement. Is that correct?
There are two outstanding issues right now, Your Honor, that the part that we have not agreed on. I think we've resolved all other language issues.
What are the issues? They've not been set.
What the heck, Streamlabs? Why are you failing me when Nabel says 11 months? 11 months of support, I appreciate that. I see it. Even if Streamlabs refuses to, Nabel, don't take that to heart. Please know that I appreciate. Oh! Okay, well, I don't want to point. I don't want to call favorites, but Jesus, Streamlabs. Carla, cool. Nabel, I don't know why they don't want to show that, but I'll thank both of you. Nabel for 11 months and Carla for 8. Thank you, thank you, thank you for the support. Oh, I forgot blush. And John, 10 months, genital jousting. I saw it on your stream. That's the pork I made, by the way. I made 2.5 pounds of pork carnitas. Woo! I made that and cookies this afternoon.
Forth on any of the pleadings.
Well, Judge, we've been shuffling a proposed judgment back and forth. We did get the transcript. We've gone through it page by page. And as Mr. Chappell indicated, there are just two issues that we would like the court to determine. And I'm happy to start with the easy one first, Judge.
Yeah.
The parties are required to communicate by app close. I have asked that the communications be civil and respectful and that the judgment state as much. And for some reason, the defendant does not want to consent to language that would require the parties to be civil and respectful. That's the easy one.
Well, obviously that's implied. It should be civil and respectful. Mr. Chappell, who's going to respond? Mr. Chappell or Ms. Kuhn? Why?
Your Honor, I'll be, Your Honor,
Oh, wait. Why wouldn't you not want to be respectful? Hi, Ben. Oh my God. What a good little case here. I do recall a little bit of this. Remember, not only do we have one lawyer for one of these people, we have two. Okay? So keep that in mind. Two of them.
I'll be happy
What's
to
your opposition to
respond.
the words civil and respectful?
Yeah, the concern is we're creating something and putting something in a judgment of divorce where someone then has the ability to come to court and make an argument that, you know, you weren't civil, you weren't respectful, which are very subjective determinations, and therefore try to hold someone in contempt of court. It may seem unorthodox, Your Honor. We'd like to all believe that the parties are going to, you know, always be civil, always be respectful, but this is a case where we couldn't even agree on what the definition of summer meant. So the concern is this, is that it will just be one more avenue for Mr. Mansick to come in and say, I don't think you're being civil. I don't think you're being respectful. And then the court has to determine what those terms actually are.
Well, I think this court can use common sense to determine whether something is civil and respectful or not. I don't think it requires a legal determination or judicial determination. It's simply common sense.
Yeah. And understand that would be the standard always, Your Honor. We're just trying to avoid avenues where it will create further litigation.
Well, perhaps the best way to avoid that is to spell it out. So yes, the court will approve putting the words civil and respectful communication by app close.
Thank you, Judge. The other issue is as to custody and parenting time, and I'm sure you have a copy of the transcript in the file. You'll recall this was a little unorthodox. The parties wanted to get divorced and they were waiting for a report and recommendations from Dr. Wooten. And for that reason, we put an agreement on the record making custody and parenting time subject to Dr. Wooten's report and recommendations. That if Dr. Wooten issued a report or made recommendations, that either party could come back and that report would constitute proper cause or a change in circumstance, and either party could ask for this court to make a different determination about custody and parenting time other than joint, which is what they were exercising. Initially, defendant's counsel wanted the judgment to say that the custody and parenting time were temporary and without prejudice. And I was uncomfortable with the word temporary because I didn't think a judgment could say that custody and parenting time were temporary, but we ordered the transcript and counsel was right. The agreement was that custody and parenting time would be temporary and without prejudice. Today, counsel is asking to insert that custody and parenting time are reserved. And I take exception to a judgment of divorce reserving custody and parenting time. I think a judgment of divorce has to decide custody and parenting time. So we looked at the transcript, and the basis for their use of the term reserved was your honor's use of it when you called the case and and announced that there was a settlement, you stated, and this is at page 4 of the transcript at the bottom, Mr. Godfrey has informed the court that the parties have reached an agreement on all outstanding issues with the exception of custody and parenting time and wish to reserve that issue until receipt of Dr. Wooten's custody and parenting time evaluation. Is that correct, Ms. Zagorski? I said yes. Ms. DeVoot's counsel said yes. And then Mr. Godfrey put the agreement on the record, and he said custody and parenting time are temporary and pending further order of the court without prejudice. That is the language that the parties approved, temporary and without prejudice. The court's use of the word reservation, or that it was reserved, I don't think was intended to bind the parties. And my client didn't intend for that issue to be reserved, nor did I, even though I did say, yes, Your Honor. And so the argument is whether custody and parenting time are reserved or temporary and without prejudice.
Well, perhaps the court inappropriately used the word reserved. I just knew that there was not a full and final agreement on custody and parenting time. So I think it's more appropriate that the judgment provided as temporary and without prejudice.
Thank you.
So in other words, when Dr. Wooten, if he submits his report, the parties can come back before this court.
Well, and the problem with that, Your Honor, is that's not the limit of what the parties agreed to. So now we're going to have to get into other language because Mr. Godfrey also made it clear, and this is why it was reserved, and this is why we think that the words are important. Mr. Godfrey made very clear on page 5 of the transcript that you could come back in for a change of circumstances for Dr. Wooten's report, okay? In addition, if you look at pages 17, 18, and 19, neither party is prevented from bringing up matters or actions or acts that they think is important that predates this agreement. That's why reservation is important. If we don't have the words reserve in there, then we need to include the language in there that everything is open. Because here's why we believe it's important to the plaintiff. We're going to hear an argument down the road that, once a motion to modify is filed, because there is one coming, that there's certain things that you can include and there's certain things you can't include. So the reserve language, which was what the court asked at the very beginning, signifies that it's open, it's wide open.
The problem with, I'm sorry.
And we don't want to limit, anyone's consideration of what occurs just based upon Dr. Wooten's report.
The problem with Mr. Chappell's argument, Your Honor, is that I have approved language that says the parties stipulate and agree that when Dr. Richard Wooten's report and recommendations are issued, that Dr. Wooten's report is sufficient and adequate grounds for either party to seek a modification of parenting time or custody. Accordingly, this judgment shall not operate to stop either party from raising any issue that predates the judgment of divorce as part of a party's request to change custody or modify parenting time. So Mr. Chappell's requested language is already in there. It was in my original draft. I just don't think that the custody and parenting time provision should say reserved because this court used the word reserved when that's not what the parties agreed.
But that was the predicate of the agreement. It was the first thing we said when we came into court.
And
That's
that,
what the court said. That's what the court said.
But Judge, we confirmed that that's what our intent was.
the clients did not.
Well, they were next to us. I mean, it's hard to say that the clients didn't confirm it when they're sitting right next to us and we're speaking on their behalf.
I don't, Judge, I don't think that you were speaking with any intent to bind the parties. You were calling the case and introducing what you understood to be the situation. And then Mr. Godfrey read the agreement into the record and the parties confirmed their agreement.
Your Honor, do you have the transcript by chance?
Yes, I do. And I think I'm gonna have the parties brief this issue. I'm asked to look at page 5 and 17, 18, 19. I'm trying to grasp because this court did not play any part in the negotiations, the agreement. That was Attorney Godfrey. Perhaps you should confer with Attorney Godfrey so he can clarify what his recommendation was, because I believe the parties adopted and accepted the recommendation of Mediator Godfrey.
Correct, Your Honor, and that's what you stated. You stated Mr. Godfrey has informed the court that the parties have reached an agreement on all outstanding issues with the exception of custody and parenting time and wish to reserve that issue until receipt of Dr. Wooten's custody and parenting time evaluation. Is that correct, Ms. Zagorski? Ms. Zagorski says yes. The court, is that correct, Ms. Kuhn and Mr. Chappell? We say yes. The court says, okay. So, I mean, that was the basis. And now the problem is this judgment has been sitting here and hasn't been entered, and we have Dr. Wooten's report, and I'm waiting to file a motion, and I can't even file a motion, and I don't want to hear opposing counsel then make the argument, well, you've had Dr. Wooten's report now for so long, so it's not a proper change. I mean, this is just all getting so backlogged because the judgment hasn't been entered. And I think the reservation language is very important because that's exactly what we did, Your Honor. And that's what Mr. Godfrey had stated to you. And you asked us that exact question. And we said, yes, Your Honor, that is our agreement. That is our understanding. So I think it's disingenuous to go backwards and say, well, our clients didn't state it. Sure they did. When we questioned them at the end, if this was their agreement, they absolutely did. And when we make a statement to the court stating, yes, this is our agreement, and our clients are right next to us, we've conferred with our clients. And I would think that the clients would bring it to the court's attention if the attorneys aren't being honest and forthright and haven't conferred with the clients and haven't represented properly. The court we know. So I think that the argument that that's not what we agreed on when we affirmatively stated to the court that's what we agreed on is not, it's being made, and it's very clear that the transcript states that we did in fact.
What if the judgment included the following language that custody and parenting time is temporary and without prejudice and reserved until final until receipt of Dr. Wooten's report?
We have the report, Your Honor, already. That's the problem.
Okay. Okay, so does someone, because based on that report, someone wants to have a hearing on custody and parenting time, is that correct?
Yes, I'm going to be
Okay,
filing
why
a
don't we just set a
motion.
hearing then? The parties can get divorced in 2025.
We had the mediation and we agreed to reserve custody and parenting time, Your Honor. So I don't
Okay.
know why.
Okay, let's set it for hearing now. Do we need to set a trial date? I mean, I don't know if we want to talk with Godfrey. I thought there were some parameters, but if there's something new in Dr. Wooten's report, then I guess either party can file a motion. We will conduct a hearing. So should we just schedule a hearing today, sometime in January or February?
I'll be filing a motion to release support.
Hi, Jonathan. I was worried about you. Are you doing better today? Were you feeling sick yesterday? Thinking about you. Also, hi, anybody that just came in. Welcome, welcome, welcome. We're digging into the archives. Also, I'm munching back on some delicious cookies that I just made. I wish you were here to share them with me. Some people have been so lucky as to taste my cookies.
To release the report to another expert. So I need to get that motion to you. My intent was to get that motion filed once this judgment of divorce was in.
Okay, well, if we can't resolve this issue, we cannot enter the judgment of divorce. I thought the parties wanted to be divorced in 2024. But if you want, I'll give you a hearing date, and we'll address at a hearing date for a couple of days of a trial. You can bring in all your, if you want to depose Wooten, if you'll appear for a trial, and we can put some finality to this issue of custody and parenting time. I thought the parties, this court's opinion, the parties should share joint legal custody. Don't worry about physical, it's just joint legal with parenting time. I have not read the full transcript, so I don't even know what the issue was, so I'm not really prepared to address that. I don't recall exactly what the agreement was of the parties relative to custody and parenting time on a temporary basis.
They do a 223, Judge, and they have been since June of 2023.
So it's just a parenting time issue then. Unless there's something new that's been brought to the party's attention by Dr. Wooten. One party's got some psychological issues or problems.
There's some issues with Dr. Wooten's report, Your Honor, and the motion is requesting the release of the report to Dr. Gunsberg who is an expert, who's going to be reviewing the report. She would be our expert. And I'm sure Ms. Zagorski is going to use Dr. Wooten. I'm assuming.
I hate to see the parties continue to incur significant expense. And it sounds like the 223 has been working. And that was a temporary arrangement. Is that correct? It was a joint legal with a 223 parenting time schedule. Is that what the
Yes.
agreement provided
Yes.
for?
Back in June of 2023, Judge, we did a 223 schedule, joint legal, joint physical.
Your Honor, there's been ongoing issues with respect to what's occurring with the minor child. And
I don't know of any. My client
Yeah.
doesn't know of any.
the minor child has ongoing play therapy as well, Your Honor.
That was agreed to. I think my
Yeah.
client requested it. It's been very successful and effective.
Well, we debate there's things occurring that we believe bear on custody as well, Your Honor.
Judge, my
Okay,
client
so
is
you can
gonna
file a
be-
motion then, Mr. Chappell? You file a motion to modify custody?
Well, that's where, but again, as Ms. Kuhn indicated, we will have an expert witness, but we need to have that report released. I mean, I suppose if we could agree, if everyone would agree to to a stipulation that we could file after the hearing today to have the report released, that would expedite it.
This is the first I'm hearing of it, Judge, and I would ask you to remember this when you consider my request for attorney fees. My client just wants to be divorced and he wants his child to be healthy and happy.
Can we accomplish entering the judgment and then reserving your right to file a motion to modify, Mr. Chappell?
Yeah, we believe, obviously, we believe that it's important to have the reservation language that we agreed upon in the judgment.
It wasn't agreed upon. It was the judge's language. The parties never assented to it. I would propose this. We do temporary and without prejudice, and either party's right to file a motion is reserved. How's
How about
that?
that? That seems to cover Mr. Chappell. Repeat that
No,
again,
it-
Mr. Gorski, that custody parent time be temporary without prejudice.
Either parent, either party's right to file a motion to modify it is reserved.
Well, what's wrong with the language? I mean, here's what we have, Judge, okay? I mean, it's a matter of where it's placed. The parties, what we've proposed is the parties agree that the issue of custody and parenting time are reserved, period. And then we go on to state that temporarily and pending further order of the court without prejudice, the parties shall share joint legal and joint physical custody of the minor child.
We don't agree that custody and parenting time are reserved, Mr. Chappell.
How are they not reserved?
I will agree that
What have we concluded?
file a motion is reserved. I do not agree that we reserved custody and parenting time. I don't agree with that.
What have we concluded in the realm of custody and parenting time, Ms. Zagorski?
That they're temporary and without prejudice. That's what Mr. Godfrey read into the record, and that's what the parties stated they agreed with under oath. They said yes.
And that's what we have in the judgment.
And you also have that it's reserved. And my client never agreed to that. I agreed when the judge asked the question, but that is a different animal than the parties agreeing to that being a part of their judgment of divorce.
Well, I think if you had an issue, it would have been raised at the time the judge asked the question and you would have said, no, Judge, I don't believe we're reserving it.
Well, I'm sorry, but Mr. Godfrey stated something else. The judge wasn't reading the parties' agreement into the record. The judge was asking a question. I
It's the
didn't bind
predicate-
my client by answering the judge's question. He wasn't under oath and he didn't say yes. I did not bind him to that.
You
It
did
was the
bind him to
predicate.
that.
I
It
did
was
not.
it was the predicate of the agreement.
Well, we don't make agreements based on predicates. We
We
make
sure
agreements
do.
based on the language on the record.
Where
That
the
is
court,
language.
the court would agree this court's use of the word reserve was perhaps inappropriate. I was just prefacing the commencement of calling this case. But I noticed on page 5, when the court asked Mr. Godfrey to state here in the record, he first of all starts out stating on page 5, temporarily and pending further order of the court and without prejudice, the parties would share joint legal and joint physical custody. So that is the language that the court will adopt in this judgment. We don't need to put the word reserved. If the court has no objection to Mr. Gorski, including that additional language about the parties' right to modify custody and parenting time is reserved. I don't know, I didn't write down exactly what you suggested, Mr. Gorski, but that gives them a little bit of opening.
Yeah, Judge, I don't intend to file a motion, and this court has jurisdiction over the parties. If they believe that custody and parenting time are properly changed, they'll let you know how and why.
Your Honor, then we don't have an agreement because Mr. Godfrey spoke to you, told you that we were doing this, we were reserving custody and parenting time. When we mediated, we were not going to do anything different with the custody and parenting time during mediation because we didn't have the report. Now that we have the report, there are issues, there are continuing issues. We did not agree that we would just say it's just temporarily and without prejudice. We wanted the issues reserved.
In other words, Mr. Godfrey never used the word reserve, but in any event, what if I get Mr. Godfrey on the phone right now? Do you have a few minutes? See if he's available to zoom in?
Yes.
Oh, the good old days of arguing about the littlest
Let's call him from
thing.
the bench, see whether he's available.
I'm so glad you're all here with me tonight. Please make sure that you hit the like button, that you are subscribed. Oh my God. That's
Okay.
amazing.
Mark Brown is still available.
We're gonna hear the
I just don't know
call.
if you can zoom in. I got the parties in court relative to the Mansick and DeVoot matter. Kim Kuhn, Eric Chappell, Maria Zagorski, trying to finalize some language in the judgment. And I thought if by chance he was available and he could zoom in, and he perhaps could join the discussion. Okay, but yeah, when he can finish it. Yeah, that'd be great if he could. All right, thank you.
Chocolate chip
Thank
cookies,
you.
Jonathan.
Bye-bye.
My
Bye.
specialty.
Mr. Godfrey's on the phone, but someone's gonna hand him a note and they think he'll be available to join in on the Zoom.
He's gonna join in like a weird orgy of lawyers and money alike. Probably at least one dyke. That wasn't meant to be rude.
Okay. Yeah, Tom will notify him when you're ready. Okay. While I'm waiting for Mr. Godfrey, Mr. Chappie also suggested, or somebody suggested pages, now at 5, but 17, 18, and 19 of the transcript also addressed the issue.
The
I
lawyers
think
have
those are all
LA
financial
cousins.
issues, Your Honor. If I could, while everyone is on the line, we knew that apparently something was happening at 3:15 with the court, Your Honor. We were concerned about Zoom. But there was one other issue I'd like to raise. It's a small issue. On page 8, Maria, under personal property, the parties had established a date, Your Honor, by which they would provide Attorney Godfrey with any lists regarding personal property. We extended the other dates that relied upon the judgment being entered. I think that date should be extended as well. Maybe we give them like 30 days after the entry or something.
It already was. Kim made that change already and I approved.
Okay, all right, it wasn't on mine, so.
And you've made that, so we're working off the judgment that Ms. Gorski prepared.
Well, we were
Okay, Mr. Godfrey is zooming
we were
in.
working off of the first objective
Zooming
judgment,
in.
the one that
Mr.
Kim
Godfrey and Larry,
prepared
you're
in
so
response
right.
to my judgment. And now there's a third one, which changed things again. So it's getting a little confusing, Judge.
We have that if the parties are unable to agree as to the division of their personal property, they shall request an arbitration with William Godfrey on or before January 31, 2025.
I did send you the transcript, Bill. Tammy has it.
Right. For the record, Attorney William and Mediator Godfrey is present. Thank you, Mr. Godfrey, for short notice of zooming in. And the matter is before the court this afternoon on the defendant's objection to entry of the proposed judgment. Mr. Gorski is present representing the plaintiff, of course, and Ms. Kuhn and Mr. Chappell are present representing the defendant, Rebecca DeVoot. And the issue appears to be, they have received Dr. Wooten's report. We may be having a motion filed relative to custody and parenting time. The issue is that Ms. Gorski, your language on page 5 of the transcript, you have a copy of that. You indicated that temporarily and pending further order of the court and without prejudice, the parties shall share joint legal and joint physical custody.
My notes, Judge, indicate that the custody arrangement is, quote, temporary, close quote, and quote, without prejudice, close quote, to either party. I can indicate the reason why was we had not yet received Dr. Walton's report. And we had adjourned, I mean, this was our third mediation with the parties. And no one could give me an idea when we would end up with that report. So my thought process was when you get the report, file whatever actions you need to do dealing with the custody matters.
Your Honor, if I may, Bill, do you have a copy of the transcript?
Credence. Wait. Quote, Credence quote. Shocked, shooketh. Color me surprised. How are you doing? Hope you're well. I'm not in the kitchen right now, but I can prove that I'm really close, and I was there earlier cooking, baking, naked. Hold the phone as we watch these lawyers argue.
Tammy is not. I mean,
Okay, I understand. I mean, because there's I know, Your Honor, you referred him to page 5, but when we came into court, the issue, I'll wait for him to come back.
Oh my God, he was waiting for me to come back with the cookies? How?
It was our intention to reserve the issue of custody and parenting time. And that was the first thing that was addressed when we appeared in court. And I'll just read it since you don't have it, page line 20. The court, Mr. Godfrey has informed the court that the parties have reached an agreement on all outstanding issues with the exception of custody and parenting, and wish to reserve that issue until receipt of Dr. Wooten's custody and parenting time evaluation. And then both counsel, Ms. Zagorski and myself, were asked if that was correct, and we both indicated correct. We believe it is important to include language in the judgment of divorce, which indicates our understanding that the issue of custody and parenting time was being reserved. We have no issue saying that, we have no issue saying that that we put the temporary language in there. But on page, that was from our perspective, that was the predicate of the agreement, is that the parties were reserving the issue of parenting time and custody.
And Mr. Godfrey, I have no idea the content of your conversation with the court when you called the judge and told him that we had an agreement and we would be putting it on the record. I don't know whether you said that custody and parenting time were going to be reserved or not, but the judge stated that was his understanding. And your letter to us and the transcript reflect you stating that it was temporary and without prejudice and not reserved.
That's correct. Mr. Godfrey and the court did not discuss anything in detail. The court, perhaps, as I stated before, perhaps inappropriately used the word reserved. I just knew that it was not a final agreement on custody and parenting time. That's all I was trying to say. So I perhaps inappropriately used the words. Mr. Godfrey did not use the word reserved, Mr. Chappell and Ms. Kuhn. So Mr. Godfrey, that seems to be the rub here in the issue.
Well, Judge, I think on page 5, I indicated that if they wanted to bring up topics or issues with the children going back 2 years, 3 years, or whatever, they could, which I don't know what I mean, I wish I had Wooten's report, or the parties were disagreeing with Wooten's report, but we had been pushing it and pushing it out. I don't know what else to do in those circumstances.
We just want to make it clear that we're not precluded from raising any issues whatsoever because none of us had that report. We don't want there to be an argument made down the road that when this motion gets filed, that there's some preclusive effect from the judgment. That's why we felt the reservation language was important.
I've agreed to language that says that. It was included in my original judgment, which says that the judgment shall not operate as a bar to issues that preceded it.
In addition, though, the concern is that I also don't want the argument, and this is why I wanted it reserved as well, that the parties have been exercising this parenting time arrangement for a long time now, and that precludes any argument that a motion to modify or to change is not appropriate. There is case law that does allow for the parties to have temporary agreements, reservations by agreements, and the court has upheld those. I have case law. My concern is I don't want to have an argument or see an emotion from opposing counsel. This arrangement's been going on since 2023, and no court, you just need to deny this without an evidentiary hearing because this is what the parties have done. We don't want to be denied an evidentiary hearing. That's why reserving it was important. That's why when the court stated, okay, it's reserved, we were good with it. That was our understanding.
What about the language that custody and parenting time is temporary and without prejudice, reserving the right to seek modification upon receipt of Dr. Wooten's report?
No objection.
Reserving the right, but
Reserving the
then,
right to seek modification upon receipt of Dr. Wooten's report.
So now we have the court speaks through its order. So now we have an issue where someone can raise that, the reservation is the report. And we made these decisions. And so what can come in, what can't come in?
But the reservation was the report, Mr. Chappell.
It is not. You got to look at page 5. You have to look at page 5. Bill made it very clear that we could bring in anything.
Bring up.
God damn it, Bill! You're always inserting funny comments everywhere, and you do it in court too. Seriously though, Bill, you're always full of hilarious comments. Hey, there's Billy Buzz Smith, another Billy around these blocks. Hi.
Matters or actions or acts that they think is important that predates any part of that agreement.
Correct.
there is case law out there that states a temporary arrangement can just basically become the permanent arrangement. That's what I'm trying to avoid. I don't want to have an issue on appeal because the language in the judgment didn't encompass what the agreement was. The agreement was that once we got the report and we looked at the report, if somebody wanted to file a motion, they absolutely could, and it wouldn't bar any evidentiary hearing, and that the longstanding arrangement of the parties would not in any way persuade the court to continue that. That's why we wanted everything to just be reserved. So that's my issue, Your Honor. If it goes up on appeal, that would be the issue. That's why we wanted everything reserved. We talked about no proper cause, no change in circumstances, the ability to automatically have an evidentiary hearing on this matter, not convincing you that the longstanding arrangement isn't appropriate. It was to be able to go to hearing if necessary. So that's what I'm concerned about. And that's why I think the language in the judgment needs to ensure that the parties have that ability. Because yes, I am filing a motion. Yes, I'm going to be asking to release the report as well as Dr. Wooten's notes, his test results, everything to our expert.
But
So
here's the problem, Judge, I think she just put it on the head of a pin. The bottom line is that they want a custody hearing, but what we agreed is found on page 5 at line 15. The parties would stipulate and agree that Dr. Wooten's report would be sufficient for any party. Not anything, Dr. Wooten's report. That was the agreement. And I now understand what the controversy is here, is that council is trying to get in the back door and create an agreement where none existed. We agreed that Dr. Wooten's report would be the basis,
We,
not Dr. somebody else, not their expert, Dr. Wooten.
so you're ignoring the rest of the language on page 5. And Bill even said that we can go back 2 years, 3 years, they can bring up anything they want involving parenting time, custody, etc. So, I mean, this is the very issue that we are concerned about, Your Honor, because there will be an attempt to limit it. And it's very clear from what was put on the record that everything was open. Everything.
Neither party is prevented from bringing up those matters in the context of Dr. Wooten's report. That's what it says.
It does not say that.
Does not.
Start at line 15 and read to line 20. No, read to line.
So if they want to go back 2 years, 3 years, they can bring up anything they want involving parenting time, custody, obviously subject to what weight the court gives it.
But
But
Dr.
Dr.
Wooten's
report that we just don't have, and frankly, Judge, I'm tired of waiting for it. So we're going forward with what we've got. No one could have agreed that Dr. Wooten's report was the only act because we didn't have it. There's no way that anyone was limited from it because we didn't have it.
Dr. Wooten's report would be sufficient for any party to seek a change in parenting time. Dr. Wooten's report, that's what we were waiting for. That is the nexus to a change in custody.
We did not have Dr. Wooten's report.
Peter learning to paint. Oh my God, I love that idea for a channel. And thank you, Miss Donna. Orlando Chiquita. Looked at the weather forecast for your area this week. A little bit thundery. Miss Donna, please stay safe. Love you so much. Seriously, Peter, that's awesome. Maybe we'll check out Peter's channel, or you should check it out later, guys. I love when people start little channels, just like Cellulite Yoga Pants, who is safe, by the way. Actually, just momentarily mentioning, obviously we have Texas fam. Please send your prayers to them tonight with all that flash flooding that happened yesterday. Cellulite Yoga Pants is away in Oregon, and she is A-okay, but please keep everybody in your thoughts. And thank you again, Miss Donna. It's still happening, Adam. Oh my gosh. Insane. Insane. Seriously. We are sending good vibes. And hopefully the sun. And William, of course you do. You hate everything.
We didn't know what it would state. As Mr. Godfrey had stated, we moved forward and reserved issues, made the custody and parenting time as temporary as we could, because we didn't know what we were doing with custody and parenting time. We did not have Dr. Wooten's report. We have Dr. Wooten's report. We don't have a judgment entered. I don't want an argument that Wooten's report was the end all of it. In fact, I have to have an expert to refute or to look at Dr. Wooten's report, because Dr. Wooten, I'm sure Ms. Zagorski's going to put him on the stand. It's common sense, Judge. If there's an issue with the report, if Dr. Wooten did not properly do something, or if there are issues and concerns that things weren't done, the court needs to hear it. And we didn't have that information at the time we mediated custody and parenting time, and that's why we wanted it reserved, temporary, without prejudice, with the ability to have an evidentiary hearing. Once we received the report, we were able to evaluate it, figure out what it did or didn't do, if there are any issues, and there are issues, as well as other issues, Your Honor. That's the also, as Mr. Chappell had stated, that's why we didn't just limit it to Dr. Wooten's report. There are other issues going back. We kept it
Okay,
wide
let's-
open.
I think we're
We
better
kept
off
it
to set
wide
a trial. Let's just set a custody parenting time trial. Obviously, if this 2-2-3 schedule has been going on for the last year and a half, again, we'll give you a hearing, even though there may not be a sufficient change of circumstances under Varka, but it seems to be working to the court. There's been a lot of issues. obviously that Woburn report was meant to just to assist the parties and reach their own agreement. But obviously, if they cannot, let's just set a custody and divorce trial, and we will hold off entering the judgment divorce till sometime in 2025.
Your
Mr.
Honor,
Godfrey, do
we
you have
had
any
actually-
suggestions? I don't want to waste any
Yep.
more of your time. I know you've spent 3 mediation sessions with the parties, and I thought we had a framework of an agreement, but we don't. And I guess rather than going back and forth, let's just set a custody and parenting time trial. Ms. Kuhn, you want to hire another expert, is that correct?
Yes, Your Honor, and I need to release the report and I need, I was gonna file the motion, with the order, allowing Dr. Gunsberg to get the raw data for the testing results, the notes, all of the documentation that had been provided to Dr. Wooten, and to release the report to Dr. Gunsberg.
The parties are not, the parties going to perhaps reconcile, they don't want to get divorced. I know the intent was to get divorced in 2024.
Judge, are you insane? Did he just suggest that they fucking get back together? No! 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 If ever there was a way to suggest to a lawyer how to make a lot of money. What in the actual fuck? One of them has 2 lawyers. The other has another lawyer. They have been fighting about this for fucking 40 minutes. And you want them to get back together? Do you have a makeup sex kink, Judge? Is that what's going on here? In fact, that's actually a probably pretty good kink. But I only want the real stuff. None of this fake shit.
For tax reasons, I don't know if there was tax reasons, other reasons why they wanted to conclude this matter this year.
They've been filing married, filing separate anyway, Your Honor, and they're not reconciling.
All right. Do you want to just, we'll adjourn this matter without date. Ms. Kuhn, if you want to then go ahead and file your motion, and then at that time, Ms. Zagorski can respond if she gets involved in the case, and then at that time, the court can set the trial date on the issue of custody and parenting time. Until then, the joint physical with 223 will continue until further order of the court.
Thank you, Your Honor.
Thank you, Judge.
Anything further, Mr. Godfrey? Do you have any suggestions? I don't know. I don't think there's any purpose served with you meeting with parties any further.
I have not seen Dr. Wooten's report, Judge, so I don't know if there's anything I can do after seeing that to help the parties.
All right. Anything further then this afternoon, Ms. Zagorski, Mr. Chappell, Ms. Kuhn? I'm open to any suggestions.
Not at this time, Your Honor. Thank you.
Thank you, Judge.
All right. Thank you, Mr. Godfrey, for zooming in at short notice. The court appreciates it.
Thank you.
Yep, thank you, Bill.
Thank you.
I received a text message from Courtney that said, next case. So give me a minute while I gather it up. And I'm doing that because I love Miss Courtney so much. Today being her birthday, she was trying to be here. So we'll drag this out a little bit. We'll try again. Give me 1 second. Pull it up. You want to know how many downloaded hearings of this judge I have? Just downloaded, not recorded. I have over 131 of his. I have a hoarding problem. It's something that I hide. Except for the internet, with which I tell the truth to. Why? Why? Why, Paisley? Why? How did I find it before? Oh, it's because it's still already sorted. You dumbass bitch. Okay, here we go. It is Courtney's birthday and Beverly soon. Christopher Engleby's 2 and Reseller Road Trip Adventure.
After this matter is before the court for the purpose of reviewing parenting time. This hearing is being conducted via Zoom. The president is the plaintiff mother, Danielle Whitaker. In addition, attorney Timothy Churchill is present, representing the defendant, Father Brian Jansen. Mr. Jansen is present. Good morning, everyone.
Good morning.
This matter was before the court on the defendant's motion to modify parenting time. When the parties were last in court, the court.
Your
ordered
Honor,
that
I am
the-
so sorry. I cannot hear you at all.
I'm sorry.
It's so soft. I cannot hear anything.
Okay, I'll adjust this microphone. Maybe you can turn up your volume on your phone. I'm not sure. I wasn't aware that there was any issues this morning. In any event, this matter is before the court on the defendant father's motion to modify parenting time. When the parties were last before the court on September 4th, the court ordered that the minor child be interviewed by Ms. Pratt this morning, and then the parties appear later this morning for a review of that issue. Appears that we lost Ms. Whitaker. Oh, Ms. Whitaker,
Yes.
can you hear the court?
Yes, I'm here. I just had to stop my video so that I can have the phone up to my ear. I can hear everything you're saying. I just cannot hear when it's not up to my ear. I'm so sorry.
Okay, but yeah, definitely stop and interrupt me if in fact you cannot hear.
Okay, I will. I can hear you perfectly now. I just can't see.
Okay, that's fine as long as we can communicate.
Yes, thank you.
Mr. Pratt, obviously, we have a 12-year-old child here, Mr. Pratt. Presumably interviewed Evan this morning. I'm
Yes,
not
Your
sure
Honor,
what
I
the
did. I had the
recommendation is.
pleasure of meeting with him this morning.
Okay. Mr. Pratt, do you have a recommendation for the court? There's some in the queue which says motion change parenting time, and it's blank after that.
The bottom, the very last part where the notes are, it says motion to change parenting time be denied. My recommendation is we leave things as they are today, Your Honor.
Okay. The copy of the recommendation the court's queue does not have the words be denied.
Let me get that fixed. I apologize.
So obviously, Mr. Pratt, having interviewed Evan, has determined that it's best interest of Evan that the parenting time continue as previously ordered and that it not be modified at this point in time. Presumably, Ms. Whitaker is agreeable with that recommendation. Mr. Churchill.
Well, my client, Your Honor, is not agreeable with it. I know the front of the court felt before having two additional half siblings was not any change of circumstances when I asserted otherwise. I know right now our concern is this. I mean, the parties had a history of joint legal physical, school started. My client's at 143 days now. There have been no problems with the week on, week off through the summer. That's what my client really, however, this 11-day stretch has to go without seeing the child. It's a long time, and the child has complained before. I won't get to see it for almost 2 weeks. And this is a father that's involved with the child's life, and that gap in there on that extra week, he right now has every Friday afternoon through Monday morning, the first 3 weekends of the month, and it's that last week that results in an 11-day break before he gets to see the child at all. And we weren't seeking any reduction in support or anything, just an extra day or two, or to get part of that other weekend. She has them all week during the weeks, and I think there is a change in circumstances when you bring into a new relationship that the child bonds with and likes to see and has a good relationship with. And I've made before, and we still stand on those issues there too. So.
All right, thank you, Mr. Churchill. But obviously, Mr. Jansen can go to a cross-country or track meet and see his son, can he not?
Yes,
Yeah,
and I
he does
have.
that occasionally, but he,
Across the hall.
Mr. Churchill, maybe you should come back in the courtroom. You're breaking up. Your reception is very bad. If you're across the hall, if you want to come into the courtroom, it'd be much easier to communicate.
yeah, I can do that, Your Honor. I am right across the hall.
It's actually
Okay.
false. False. It's gonna be worse.
Okay, I'll be right there.
It'll be absolutely worse for us. judge telling absolute lies. But basically, this dad just wants a few extra days a month. He's not asking for a reduction in support. He'll pay the same amount. But mom says, no way, Jose, get the fuck out of our lives.
All right, Mr. Churchill is in the courtroom. Perhaps we can be much easier to communicate. The question the court had is Mr. Jansen always can see his son when he practices or participates in cross-country or track meets.
Yes, Your Honor.
Turn around the microphone, please, Sharon.
God damn it, Sharon, turn around the fucking mic. Why is it even turning the other way? Why
Part of
would
the problem
it?
if he goes to the child's events and it's on mom's days, child's afraid to come over and see father.
Well, he's got to talk with him. I mean, it's a 12-year-old. This is not a 6-year-old child. And obviously, let's assume there's changed circumstances. Any court, Ms. LaPrade is very experienced working with young people. This is a 12-year-old. This is not a 6-year-old child. So we're going to put a lot of weight in that child's input. And obviously, Ms. LaPrade has interviewed this child. And obviously, this recommendation is based on input she's received from this child, notwithstanding what dad wants or mom wants.
Your Honor.
So the only question the court had, Ms. Whitaker, is what about some additional time? And yes, the school year is important. We need consistency during the school year. What about maybe an overnight during the 4th week after cross country is concluded, but before track begins? There's a period of time. Evan does not play any winter sports, correct? He just runs cross country in the fall and track in the spring. Is that correct?
As of now, Your Honor, can you hear me?
Yes, I can hear you.
Okay, as of now, he has mentioned that he wants to do art club, which starts in the fall. But Your Honor, I would like to ask Mr. Churchill if he is aware that Brian is not spending his weekend time with Evan that he has currently. And I have all of the dates here that just since we were at court 2 weeks ago and you, Your Honor, told Brian that he needs to start attending Evan's events, correct? Even on his parenting time, Brian chose to not attend, he missed 9 hours with Evan. Did not come to his homecoming parade, had his parents pick him up, take him home, missed an hour and a half Friday. The very next day, Saturday the 14th, that was Brian's parenting day, had his parents pick him up at 10 a.m., took him to his race till after 4 p.m., gave him no sunblock and no food for the day, missed 6 hours with Evan. And then the following Saturday, the 20th, missed another hour and a half with Evan. That's all his parenting time. So can we get an answer out of Brian as to why he is still not attending Evan's events, even on his parenting time? I don't feel that giving him more time.
It's a legitimate question.
Client has a lot of responsibilities with other children. He's also a karate instructor. He works full time. I can't explain. I mean, he's always cared for the child when he has a child, and what he really does on his time is really his own business, not hers, as long as it's not harming the child. We don't micromanage everything she does.
This is parenting time. We're talking about parenting time. We're not talking about his karate time. We're talking about parenting time with Evan.
Well, when she has her parenting time, she usually sticking the kid in a room with the games.
Okay, well, that's a legitimate question. Do you want Mr. Jansen to respond to that, or you just respond on his behalf in terms of it's his time, he can do what he wants, he doesn't have to spend time with Evan if he doesn't want to during his parenting time?
I think he could answer that better than I could.
Okay. Mr. Jansen, do you want to respond to Ms. Whitaker?
Yes. So I do my best with spending the time with Evan. I know recently I've had a few issues with, for example, my car I had in the shop, and I made it a point to make sure that Evan had transportation to his race and back from his race. I do spend time with him when he's on my time. It'd be ideal to be able to have more opportunities to spend with him on my time, which is why I think the week on, week off would be the most ideal and has historically worked for us. And also, the plaintiff has complained on record that of her disinterest in the schedule regarding the lack of time she gets with Evan during the school week. saying that she, quote, is doing all the brunt of school. And then has also complained about the not having times on weekends uninterrupted by the school routine. So she's complaining about doing the brunt of schoolwork, and then also, but then on the other hand, is refusing a schedule that is mutually beneficial for both parties and is looking out for Evan's best interest. Not to mention all the other aspects that we have presented to the court as far as why the schedule would be in his best interest. Not only taking account Evan's what he had told me back then, but also all the other things that I had presented that we had presented to the court before. But I do enjoy spending time with them. I do try my best to spend the time I can with them and make sure he gets to his events if I, for some reason, am not able to. Like, for example, I had car issues with my car. I wanted to make sure I get that taken care of. And I wanted to make sure that he got up to his events and that he came back. This does not at all make me a unfit parent like the plaintiff is trying to paint the picture of me, nor has there been any accusations that my having parenting time or additional parenting time would endanger the child's physical, mental, or emotional health.
No question. No one's suggesting you're an unfit parent. No one's suggesting you're an unfit parent. You're a good parent. The question is, are you going to his cross-country practices and matches?
Yes, I have gone to them.
Okay. All right. Miss
Brian,
Whitaker
Evan had 6 events. Evan had 6 events that recently. Brian has gone to 1. And I'm sorry, but I do understand having car trouble, but when his parents, Brian's mom and dad, are coming to Brian's house to pick Evan up per Brian's request, why can't he ride with them and go to the events? I don't think that's the issue. I really don't. There's no reason.
Here's the other aspect, that while he is on my time, if I choose to have him ride up there with my parents, that is how I'm choosing to do
but
it.
when you're taking me to court for more time and you were...
Okay, hold on. Okay, we're denigrating to an argument. We're not getting an argument here. It's a legitimate question. Obviously, it's fine with your parents picking Evan up, but obviously if they're taking to an event, you should be at that event. If in fact you want more parenting time, this is not grandparent parenting time. This is parenting time for the parents. Mr. Whitaker, Mr. Jansen, Ms. Whitaker, the court just had one question. What about, obviously, this is a school year. The summer parenting time will continue week on, week off, but the school year is Evan's got a lot of activities, and we don't want to interfere with those activities. What about the fourth week of the month when between cross country and track? What's your thoughts of maybe dad having maybe a Wednesday overnight during that fourth week?
I would like to acknowledge what Brian just said about me. I am not complaining about doing the brunt work. Clearly, given my presence, I attend everything for our child. Everything. I have missed 1 event in 4 years. 1.
The question, I don't need this diatribe.
Miss Whitaker?
I am
Miss
not
Whitaker?
in agree. Yes.
What about dad having?
I am not.
What's your thoughts about dad having parenting? Hold on. Let me just repeat the question again. Maybe you can answer the question. What do you think of dad? I'm just trying to see if there's some middle ground here. What do you think of dad having Evan on the overnight on the fourth week of the month between cross country and track during the winter months?
I feel with that Evan was interviewed today. He said I'm assuming.
I'm asking you, Mom. I'm asking you. You know better than anyone. The two of you are the parents of Evan.
Yes, sir. And
I
feel
know
that
Mr. LaPrade has interviewed Evan. I know that. You don't need to tell me that, ma'am. The court's question is, what's your opinion? Are you opposed to dad having parenting time, say the fourth Wednesday of the week, the month?
I am opposed to it.
Cross country and track.
Yes, I am opposed to it, given that he is not currently spending the time he has with him. Maybe if that changes, we can revisit this in 6 months. But for right now, I think it's in Evan's best interest to keep the schedule the same.
Right, Mr. Churchill, anything further?
Again, that 11 days is a big gap. I really question her sincerity in working with him. All she seems to do is always extremely critical of everything he does, tries to micromanage everything he does. Yeah, I've got emails from the past where quote, I will never work with you with our child.
That was
child
the
should be determining
past.
His own parenting schedule. You know, and a lot of that, I don't think has changed. I don't see any harm to giving him one extra night during that period. She still has more time than he does. And it's not gonna interfere with her weekend. And it'll just lessen that gap that he has to go without seeing him, but it's almost 2 weeks.
Currently, Dad
Okay.
takes him to school on Monday morning, correct?
Yes.
How long a drive is that? All right. All right, the court's going to modify the recommendation of Mr. Pratt. And they recognizing obviously Mr. Pratt put significant weight in Evans' opinions, but the court will permit to grant father parenting time on Wednesday overnights on the 4th week of the month between cross-country and track seasons. So when cross-country is done, Evan will spend the 4th Wednesday of the month with his dad overnight until track begins.
Okay, if
Give it
that's
a
the
try.
case, then
If
I
there's
do
problems,
have,
Ms. Whitaker, you can petition saying, hey, this is not working. Evan's it's creating a lot of problems for Evan. But I've not heard that that's going to create a significant problem for him. And Mr. Jansen, you need to spend time with him on those Wednesdays. You can't be off doing something on your own and going, now, do you have karate on Wednesday nights, the 4th Wednesday of the month?
I do not.
Okay, if so, he should have Evan as part of that karate class. You got to spend
Can
time with
I-
him. This is parent time for you.
oh, sorry, I can't hear.
Right.
Go ahead, Ms. Whitaker.
My opinion to that with doing the 4th Wednesday is that we make it optional to Evan. I do not have a problem with that if that is what Evan wants to do. But I think that it should be optional going into his teenage years. And I only say this because in the past, let's say that Evan is sick. Let's say Evan is sick on a Wednesday and he doesn't want to go. Is Brian going to make him get out of bed and go? And if he doesn't, is he going to call the cops on me like he has in the past? We do not have good history of that.
Evan is a minor, Ms. Whitaker. He's a minor. He doesn't make these decisions. And so if in fact he doesn't want to go, he's got to tell his dad that. He's got to tell his dad he does not want to go. Hopefully dad will talk with him and give him some respect in terms of his opinion. But that's something that Evan's got to discuss with his dad.
Your Honor, I do
Give
have
it
some
a try.
concern
If
about
there's some
that.
problems, someone can petition the court, but the court to modify the school year parenting time by continuing the 1st, 2nd, 3rd weekends with dad, Friday at 6 till school on Monday morning. But after cross country ends, before track begins, dad will have during that window, the 4th Wednesday of the month.
So it's only during non-extracurricular activities, correct?
No, it's between cross country and track. If he's got extracurricular in the wintertime, the dad's got to make sure he gets him there.
That's what I was going to
Pick him
say.
up
So
after
let's
the
say Evan
extracurricular
wants to
activity.
do art club. He has to take him to that if it's on a Wednesday.
Well, we have an order that both parents have to agree on activities because she's just signing up unilaterally for everything.
Okay, I don't know. Is there such an order?
There's an order in place. The parents have to agree to the activity.
Okay, I'm not gonna have any parties coming back every month. Mr. Jansen, are you opposed to Evan and engaging in art class or art activity, extracurricular?
I am not opposed to that.
All right, so if the court's going on right now, I don't want to care if your proposal later on. If in fact he decides to participate in art club and that's on Wednesday, he's got to make sure that you get him to and from that, all right?
And then I think if that's the case, we can also go ahead and split up the therapy. Evan goes to therapy every 2 weeks. So Brian, is he in agreement to take Evan to one of his therapies?
Why don't you schedule a day other than the Wednesday?
I'm sorry?
Is therapy scheduled every Wednesday?
Yeah.
Okay, was it the 1st and 3rd Wednesday, the 1st and 4th Wednesday? What
2nd and
Wednesday of the
4th.
month is his counseling?
It's the 2nd and 4th Wednesday.
All right, so yes, well, that's again, yes, Mr. So he obviously is not going to engage in art club on Wednesdays if he's got counseling, correct, Ms. Whitaker?
It would just depend. I don't know what the art schedule is. He doesn't do his therapy until evening hours. She usually sees him at about 6 o'clock. because she does evening hours with him. So if he did art club, it would be till like 3 or 4, and then he would have therapy like 6 to 7.
All right.
Okay.
So if
And
that's when
then,
therapy is scheduled, Mr. Jansen, you take Evan to therapy. It's probably a good chance for the two of you to talk to and from therapy.
Well, and I've also let the plaintiff know that, hey, I can take him to any one of these appointments. However, she has historically scheduled them on times when she had him. So I've made myself available to take him to those. And it's only this month that he had them every Wednesday. Before there were Tuesdays and sometimes Mondays. But it looks like lately they just this month he had them on Wednesday. So.
And if that Wednesday counseling interferes with his art club, then the two of you as parents should try to modify that so that he can do both.
Right.
Okay.
And this
You
is the
don't
first
need
thing
the
I've
court
ever
to
heard
hold
her
your hand in
talk
every
about
little
art club
detail of his
as well.
life. The two of you need to
Okay.
communicate, work together, and make sure you can do both.
and then we
Right.
will need
And
to discuss so that it's in a court order, because I don't want any fighting when it comes of it. So if he's doing the last Wednesday overnight, if there is no school on Wednesday, are we in agreement that, what are we doing about that? Because I have to work. I can't just be available to have you pick him up at 2:30 in the afternoon. So we could do 4:30. If there's no school that last Wednesday, you can pick him up at 4:30. Unless otherwise communicated, I guess put that in a court order. And then also, what are we doing if there's no school Thursday? Is dad dropping him back off at mom's at 9 a.m., same as we do on Monday? These are all things that we're going to have to communicate about in advance.
yes, unlike this
Right.
art club that I'm just now learning about.
It's
Okay, I've got better at
it's not
11:15
even
right now. I'm gonna put
established
you in
yet.
back. Mr. LaPrade, you talk to these parties. I've got some jails waiting for me right now.
Okay.
Mr. Churchill, if you want
Yes,
to
Your Honor.
communicate with Mr. Pratt
Your
about,
Hon-
yes, it's a legitimate question if in fact there's no school pickup
Okay.
drop
And
off
Your
times.
Honor,
The
Your
court's producing
Honor,
jail arraignments right now, so I'm gonna have to talk to Mr. Pratt and we'll call you in about 15 minutes.
okay.
Okay. I'm back
Yep,
across. I
thank you.
I got jails waiting for me right now.
With the magic of editing / scrubbing ahead, we will go right back to these two fighting. And that'll end our night, you ladies and gentlemen. I'm so glad that you've been here. It's been a fucking blast. Don't forget, tomorrow night, that's right, me and you have a date. Don't be late, because I will. That's my thing. I'm always late. You don't be late. Judge, are you going to finish up this case, or what's the dealio? Oh my god. Tim, that's your floor. We like ceiling fans, not floors.
Recall. Recall the case of Danielle Whitaker versus Brian Jansen. The parties have conferred. Thank you, Mr. Pratt. With Mr. Pratt a little further, the recommendation is as follows.
In the breakout room.
Oh,
We're trying to get her out.
okay. I'm
Let's do
sorry.
it in the
Sorry.
breakout
Okay.
room. Okay, I will try, Vicky. I will look at the timing of that. I will try and make it work like that. Also, I sent the cookies away, so I can't eat anymore.
Okay.
I'm having pork for dinner, some burritos and some tacos.
I'm still waiting for Danielle to hop in.
Breakfast burritos.
She must have gotten dropped. She's not in the breakout room.
Her. So they're trying to find her. I don't know if she's calling.
Obviously, if Evan has art class.
We found Danielle. She returned from a meeting of the bitches.
Very well, the parties having discussed arrangements to exchange the minor child when there's school, when there's not school. So Mr. Pratt has provided the revised recommendation that parenting time will remain as currently ordered. However, one slight modification: on the 4th week of the month, fathers should have Wednesday overnights between the cross-country and track seasons. pick up from school, and if no school, 5 o'clock pickup. If there's no school, father will drop off Thursday morning at 9 a.m. There's no school on Thursday. That is revised recommendation. Yes, obviously, if Evan has art class, if he has counseling on Wednesdays, Mr. Jansen, you need to make sure you transport him to those activities, and hopefully he can participate in those activities, be a part of his life. Ms. Whitaker, do you understand the revised recommendation this morning?
I do, and Your Honor, your statement just now about therapy, while we were on our break, Mr. Churchill did not realize that I was still in the breakout room, and he just now said to Brian that he can contact the therapist and get the date changed so that he doesn't have to take Evan to therapy, that I have no right to schedule Evan's therapy on Brian's time for that Wednesday. So I would like to suggest, I mean, I think it's only fair to split the therapy if Brian, the only reason, like if Evan's doing therapy during the week, why, and he has the opportunity to split that with Evan, then I feel that we should do so. Do we need to go ahead and put that in a court order?
So it's really a shame you parents cannot agree on whether today is Monday or Friday, whether it's wintertime or fall. Come on.
Okay, so I guess I
Your
could
Honor,
ask Brian.
I've already provided my my feedback about that. That I have been more than willing, and I have text messages to back up as evidence that I have suggested, like, hey, I can take him to those. But
Okay.
like I said,
So if it's right now
historically,
scheduled for Wednesdays, it'll continue on Wednesdays.
So
Please
Brian,
work
you are in
together on
agreement
this.
to take Evan to his therapy?
Yes, and if in fact it's but if someone changed it, come back to court. You guys can keep coming back to court, and we'll keep fighting every week. All right. That'll conclude this hearing. The two of you need to, as parents,
Your Honor, that
try to
was
make
going to
work for
be
each
my,
other.
Your Honor, Ms.
Mr.
LaPratt asked me to speak with you because I wanted a court order for that there has got to be communication between parties before continuing filing motions to come to court. There has got to be communication.
Well, the two of you just seem incapable of doing that.
Ms. LaPratt also said that I could ask you for family therapy suggestions. Is there co-parenting therapy, family therapy? Because clearly the online course didn't work because there's still no prior communication before coming to court. So can we please put that in an order? There has to be communication before filing a motion.
We're communicating by app close, is that correct?
Correct. Ready?
All right, that's reasonable. So two of you shall communicate with each other via app close before you file a motion.
Thank you.
Your Honor, there has also been historic where the plaintiff has also not done that as well. We're
going to do that from this point forward, Mr. Jansen. From this point forward, we're going to do that. You text, you communicate with each other before you file a motion.
Thank you.
From this point forward. And you check with the therapist. Yes, if in fact, for example, if Evan, just makes common sense, if Evan has art club on Wednesdays and that's going to interfere with his counseling, talk with the counselor about changing it a different day of the week. I mean, so it should probably stay Wednesdays if that's what's been happening. Continue the Wednesdays unless his art club interferes with that.
And like I said, that art club is not even set in stone. Evan had mentioned wanting to do it.
Okay.
It's not even until October. That's why nothing has been said. But Evan is almost 13. If he wants to do something, he should be able to talk to his dad about it. I don't need to relay, you know what I mean?
Correct.
Like I had every intention of telling Brian in October, hey, Evan wants to do this art club, but it's still the middle of September.
Wait, middle of September? I thought it was, I forgot this is old. I thought she was going to say it's fucking June. No, middle of September, you probably should mention October art class, ma'am. And hi, Flusha, that's really good advice. Never bang a chick already in family therapy. Probably not an ideal way to do it. Also, I just saw, it looks like Creed's going live with his gambling. We'll see if I can stretch this out long enough to actually get it redirected there. What a way to spend a Saturday night. Gambling away your money. A little bit at a time.
the only reason it hasn't been discussed yet. Trust me, I'm very aware that we have to communicate about extracurriculars. And I have been communicating with Brian about therapy appointments. So this is what I'm talking about as far as I wish we could get into some therapy, because every response from Brian is, well, historically this, historically that. We are not in the past anymore. So I am trying to move forward. So Your Honor, do you have any suggestions for some co-parenting therapy or family therapy? I don't know what to do for the next 5 years. We still have 5 more years. And at this rate, you're going to see us another 10 times in court because it doesn't
Yep,
stop.
and I'm sure I've had you both complete the problem solving workshop. That obviously didn't, neither of you benefited from that. But again, the court will simply add this recommendation this morning that you should communicate with the other before you file any motion.
Okay, thank
I also
you.
strongly implore the courts to review the parties' communication even after that, because there's still jabs being sent from the plaintiff that are not solely goal focused on Evan and his best interest. So I would
Like
strongly
what?
implore the court to review those kind of communications as well. So.
Anything
Good luck,
further, Mr.
Brian.
Churchill? All right, that will conclude this hearing. You can both zoom out. Thank you, Mr. Pratt. If you can just add that one provision that party shall
Yes, sir.
communicate with that before filing any motions.
Yes, sir. I'll get that uploaded and in your queue.
Does that also
All right,
include contempt of court?
There's enough challenges in life, Mr. Jansen, Ms. Whitaker. Try to make it easy for each other or better for each other. There's enough challenges in life. Don't make it
And
more
Your Honor,
complicated.
I've done my best. And even like with the whole tax return, I even try to resolve it outside of court. And I told her, like, this is what needs to happen. And it only took me taking her to court in order for that to happen. So I'm not purposely trying to aggravate. I'm not purposely trying to take people to court. But when I'm trying to resolve things outside
Right.
of court and it's not happening.
Miss Whitaker has
I have-
left court, so
And that was the end of that. Okay, guys, we need to remember for tomorrow to say happy belated birthday to Courtney. Go over, watch some Creed gambling. Go do you. Have a great night. I miss you guys so much. We'll be back tomorrow. It's going to be later tomorrow night. So, do your day. We'll be back tomorrow. Thank you so much for being here. 3 Knuckles Deep Therapy. That sounds like it. Anyways, you guys, do me a favor. Remember that I love you. And I'm proud of you. And I will see you in the next video. Okay, bye. No, you're not watching the show.